You've spent your life savings on R&D. You filed the patent. You did everything right. You're working out of your garage or a small office trying to get that first major contract. And then you see it. A big corporation is using your technology without your permission. Most people think, I'll just sue them and stop them, right? But for years, there's been a frustrating trend in the courts that made it hard for the little guy to actually stop the infringement. They'd tell you, since you're not manufacturing at scale, we won't stop them. We'll just make them pay you a small fee. Well, today I'm going to tell you about an important USPTO update that just dropped. It signals a major shift in how the Patent Office is going to be more inventor-focused now. As a solo attorney, I work directly with people just like you, startups and solo inventors, who are footing the bill for every prototype and every patent filing. I recently spoke with a client who was terrified to even pitch to investors because they felt like a non-practicing entity. They worried that because they hadn't launched the product yet, their patent was essentially toothless. They felt like the system gave all the breaks to the giant corporations with deep pockets. If you felt that way, you're not alone, but the tide is turning. The USPTO and the Department of Justice just filed a statement of interest in the case Collision Communications Inc. versus Samsung Electronics in the U.S. District Court for the Eastern District of Texas. In it, they explicitly stated that the right to an injunction, which is the legal power to actually stop someone from using your invention, is a fundamental right and fundamental part of the U.S. patent system. They said that inventors who aren't practicing the patent yet, meaning you haven't hit the market or built the factory, should not automatically be denied the right to stop an infringer. Specifically, John Squires, the current Undersecretary of Commerce for Intellectual Property and the Director of the United States Patent and Trademark Office, said, and I'm going to quote, "Injunctions prevent ongoing and irreparable harm to innovators in the innovation economy and ensure that legal remedies can stop unlawfully copied inventions from continuing to harm innovators." Dina Kelly, the Deputy Assistant Attorney General of the Justice Department's Antitrust Division, she said, and I'm going to quote, "Innovation is core to dynamic competition, and vigorous competition is central to the success of the American economy. Policies that preserve incentives to innovate are therefore vital to safeguarding competition." She went on to say, "We are pleased to partner with our USPTO colleagues to address these critical issues and support innovators." Now here's the important part, both big and small. So the Patent Office is reaffirming that your patent isn't just a request for a check. This is a big win for the innovation economy, this statement that the Patent Office and Justice Department filed, because it protects the incentive for you to keep dreaming and building, even before you have millions of dollars in venture capital funding. This announcement shows that the USPTO is becoming more protective of the individual and small startups that make really this economy go. Your intellectual property has value, whether you're a Fortune 500 company or a solo founder working late nights in your garage. If you're worried about how to protect your invention, or if you've seen someone else using your technology, don't just assume the big guys have the upper hand anymore. Let's talk about your rights. I'm here to help you navigate this changing landscape personally, one-on-one, and I'm going to keep bringing you these updates from the Patent Office as they roll out. Click the link below to schedule a consultation with me. Let's make sure that your hard work is protected.